either of the teams, one speaker from either of the teams can respond to after I administer the oath. Could I request the team speakers and the other members to switch on your videos, please?
If I could give in half a minute, I seem to have some issue with my camera.
No worries, please take your time. Team Calibri, speaker 1, we are waiting for you.
Hi, sorry, I was facing a technical. I hope I'm both audible and visible.
Yes, you're perfect, audible and visible. Thank you.
So,
okay, great. So I will be administering your oath now, and the judges have already been briefed about your specific procedure which you have agreed upon, and your time and the timestamps that have been requested. So I'm going to proceed with the oath. Do you, the students of Team Calibri and Harrington, solemnly promise that you will abide by the rules of the National Law School Trilegal International Arbitration Moot Court Competition and the rules for the virtual oral pleading, and that you will not communicate with or accept assistance from in any way your coaches or other individuals during the oral pleading?
We accept.
we accept.
On behalf of the panel chair, I would like to remind you that failure to comply with the rules or to accept help from outside sources, including coaches, can result in the panel recommending your disqualification from the NLSTIAM. So, panel, we are good to go.
Welcome to the council representing the two parties in this case. I believe we're going to hear from Team Calibri for the claimant. The organizers have just asked me to play the role of the chair in a private chat. So apologies to my rest of my panelists, as much taken as by surprise as I may be, but someone has to take it off, and that happens to be me. So may I call upon the claimant speaker number 1, please.
Apologies, Mr. Arbitrator, I'm sorry to interrupt. I believe that the order that was agreed between the parties was that the RCCR format be followed. And since we, the respondents, have raised the jurisdiction issue, I shall seek permission to begin my submissions on the first two procedural issues.
Thank you. Please, you may.
Thank you, Mr. Arbitrator. Good evening, members of the tribunal. Today, I, along with my co-counsel, will be representing Cleanup First Private Limited, the respondent in the present matter. Members of the tribunal, we need to understand here that even though my client has made its best conscious effort to honor the terms of the contract, the claimant in the present case has directly invoked the arbitration clause without honoring the terms of the EPC contract, and we are here to challenge the same. In this respect, I shall plead before the tribunal for the next 20 minutes on the procedural issues, while my co-counsel will plead on the merits. Now, if the members of the tribunal are well versed with the facts of the case, I shall proceed with my submissions.
Yes, you may.
Thank you. Now, before I make my submissions, I would like to quickly apprise the tribunal of the two issues that I will be pleading today. First, we contend that the tribunal cannot conduct the hearings remotely. And second, that the tribunal cannot exercise its jurisdiction in the present case. With regard to the first issue, members of the tribunal, I will be making two key submissions. First, that the tribunal cannot unilaterally decide the mode in which the hearing is to be conducted. And secondly, I will argue that a remote hearing is in contravention to the considerations of due process in the present case. To begin with, if I may draw the attention of the tribunal to clause 25.3 of the EPC contract at annexure A, given at page number 1717 of the case study. If the tribunal is with me here, then I shall submit that the procedural aspects of this dispute are to be governed by the 2016 institutional rules of SIAC, as the same has been expressly agreed upon by the parties. Further, the law applicable to the procedural aspects of this arbitration shall be the law of Singapore, that is the Singapore's International Arbitration Act, as it is the chosen seat of the arbitration. Now, moving to the crux of my first submission, the counsel for the respondent argues that the tribunal cannot unilaterally decide the mode of hearing, as the SIAC rules require that the parties are consulted before the tribunal rules on the conduct of arbitration. To substantiate, I would like to request the members of the tribunal to refer to Rule 19.1 of the 2016 SIAC rules. And it clearly states, if I may quote the relevant part for the convenience of the tribunal, it says, the tribunal shall conduct the arbitration in such manner as it considers appropriate after consulting with the parties, unquote. Here, it is the submission of the respondent that the said rule was not complied with by the tribunal, as the parties were not at all consulted before the tribunal ruled on remote hearings in the present dispute. Members of the tribunal, if you may refer to point number 2 of paragraph 37 of the statement of facts, given at page
Counsel,
number...
if I may ask you to pause for a second, would you like to consider whether that so-called default by the tribunal can be cured by, for example, now asking the parties right away what their views are? Would that, in your view, be sufficient to cure this alleged lapse?
Mr. Arbitrator, I submit here that the consultation from the parties should have been done before the tribunal rules on the mode of hearing, and not while the hearing is being conducted by the tribunal.
You may consider it in your further arguments. Please proceed.
Thank you, Mr. Arbitrator. Now, if I may request the members of the tribunal to refer to point number 2 of paragraph 37 of the statement of facts given at page 12, 1-2. If the members of the tribunal are with me here, then you would note that after numerous applications and notices from the parties, the tribunal, via procedural order number 1, dated 31st of July 2020, determined that a physical hearing would be conducted in Asgard between 18th to 29th May 2021. However, now if the members may kindly peruse paragraph 45 of the statement of facts given at page 14. If the tribunal is with me here, then you would note that the mode of hearing was changed from physical to remote after an insistence had been made by Ms. Tokyo. Here, the counsel for the respondent submits that this switch in the mode of hearing from physical to a remote one was neither consulted upon nor previously agreed upon by the parties, and therefore we contend that this remote hearing of the present dispute is in clear contravention to the SIAC rules governing the arbitration. Now, moving on to my second key submission, I submit that the remote hearing in the present case is in contravention to the considerations of due process. We assert that according to the norms of international arbitration, the tribunal has to consult the parties and give sufficient reasons before conducting the hearings remotely, especially if such a hearing is being convened despite the objection of a party. Now, in the instant case, the tribunal had, after taking into account its complex and fact-intensive nature, decided to conduct the hearings physically in its initial procedural order. And if the members of the tribunal may kindly refer to paragraph 43 of the statement of facts, given at page number 13, here, you would note that the tribunal had even considered it appropriate to delay the hearings twice, not once, but twice, when they could not be conducted on the original dates due to the COVID pandemic. Moreover, the tribunal also shifted the hearing from Asgard to Singapore since Asgard had started reporting COVID cases. Hence, referring to these facts, we submit that the tribunal understood and recognized the importance of physical hearing in the present dispute. However, now if the members may kindly refer to paragraph 45 of the statement of facts given at page 14 of the case study. By using this fact, we respectfully contend that the tribunal changed its initial decision of conducting a physical hearing solely on account of the health of Ms. Tokyo, as she was infected with COVID. Now, and we submit that this does not serve as a sufficient ground for the tribunal to conduct the hearings remotely, particularly in light of the fact that Ms. Tokyo had caught COVID in January 2022, and the hearings were scheduled in the month of late May 2022. Now, during these almost 4 months, it is a submission that she was very likely to have recovered from COVID, given the fact that she did not have serious symptoms as per the facts. Additionally,
tell me something. So what is the submission you're making? Is the submission that there is an element of procedural irregularity which cannot be cured, as my colleague was trying to inquire from you, or is it that there is a right of physical hearing which should be enforced? Is that what the submission is?
Mr. Arbitrator, in the present case, our submission is that we indeed have a right to physical hearing, but that right, we submit that the tribunal should have conducted, if at all it wanted to conduct remote hearings, it should have given us appropriate and sufficient reasons for conducting remote hearings. However, it is a submission that in the present case, those sufficient reasons were absent.
If I may follow up, because I don't know that the answer clarified the question for me. You referred both to a right of physical hearing and I think a procedural irregularity in your answer. And the question was, which one are you arguing? So I'm not sure that I took away from your answer a response that tells me which one are you arguing. And if it is that there's a right to physical hearing, what is the legal basis, beyond the fact that this tribunal initially wanted to have a physical hearing, what is the legal basis either to say that there's a right to a physical hearing or the lack of a physical hearing is a due process violation, not the consultation process being a due process violation? You've made that argument, but what is the basis, the legal basis to support the notion that there's a right to a physical hearing or that a lack of a physical hearing is a due process violation?
Mr. Arbitrator, to answer your concern, I would be making submissions on the issue of due process violations that might be possible in the present case if remote hearing is ruled upon, which has been done in the present case. However, we base our arguments that a remote hearing in this present case is not viable because it violates due process concern, and I shall be coming to those submissions. If I may move ahead.
Go ahead. I don't think you answered my question yet.
Yes, the three members of the tribunal at least are convinced that the question remains unanswered.
Oh yes, right. Mr. Arbitrator, I shall answer the question right away.
And given that remain unanswered, I have a follow-up question which you may just answer together. Sorry, so in clause 25, it's not specific what's the seat of the arbitration, right? In your argument, somewhere you said it's Singapore, and then somewhere you said Asgard. So what's the seat of the arbitration, and what the procedural law that you're indicating would apply to this arbitration proceeding?
Mr. Arbitrator, to answer your concern regarding the seat of arbitration, I shall refer you to paragraph 37, where in point number 3, it has been mentioned that the seat of arbitration would be Singapore.
Yeah, but the para 43 that you showed, right? It says that the tribunal decided to postpone this in Singapore instead of Asgard, right? So wasn't the original seat then Asgard instead of Singapore?
Mr. Arbitrator, if you may refer to paragraph 37, clause 2, the last pointer of that says that a physical hearing could be convened in Asgard between 18 to 29 May. This Asgard place is a venue, not the seat of the arbitration. And the same was changed by the tribunal, taking into account the COVID cases that were being reported in Asgard. So the venue was changed at paragraph 33 from Asgard to Singapore. However, the seat of the arbitration still remains the same, that is the Singapore. And that's why the procedural laws and the laws of Singapore shall apply. Now, to answer the concern of Mr. Arbitrator with respect to remote hearings and the due process violations, we submit that the present case is very fact intensive in nature, and it involves various witnesses and expert evidences that need to be examined by the tribunal. Accordingly, we submit that the tribunal would be in a better position to assess the demeanor and the credibility of the witnesses if the hearing is conducted physically. Additionally, to address the concerns, there are also concerns apart from the witness examination concerns. There are also concerns about the confidentiality of the arbitration proceedings and the information that are revealed in those proceedings. Now, the tribunal.
If I can stop you, let's focus on the first argument, that the better position to evaluate the witness evidence. Do you have two questions there? A, again, do you have any legal support for the proposition that not being physically in the presence of witnesses is a due process violation? And second, what is the standard that you're applying? Let's assume for the sake of argument, and it's only for the sake of argument, that it is better. Is better or worse? If worse than better, is worse enough to get you a due process violation? Don't we need something that says that there has been such a deprivation of your right to present your case that we're concerned about whether you've had a fair hearing, as opposed to whether there's better or worse ways to do things?
To answer the concern of Mr. Arbitrator, I shall refer the members of the tribunal to the case of Sonica Industries Limited versus Puyu Manufacturing Limited of 1999, where the Singapore Court of Appeal ruled, and the court noted here that even though virtual meetings take place these days, courts and tribunals should still attach importance to being able to see and assess the demeanor of the witnesses and their credibility physically. And the court also observed that did
the court find a due process violation?
Apologies, Mr. Arbitrator.
Did the court find that there was a due process violation? Can you point us to any court that has found that there's a due process violation because of the mere fact that evidence was taken by video rather than in person?
Mr. Arbitrator, my reference to this case is to signify that the what all pointers need to be taken into account by the tribunal before ruling for a remote hearing. It is not that the facts of the case are a bit different from the current fact situation, and I'm only referring to the observation that the court has made in this case, where the court has even said that video links can be used for cross-examination. However, there would still be a great deal of detachment between the witnesses and the tribunal, which effectively affects the ability of the tribunal to assess the credibility of the witnesses. If I may now move ahead with my submissions.
It's fine with me, thank you.
Thank you, Mr. Arbitrator. Now, therefore, in light of these submissions, the counsel for the respondent categorically objects to the decision of the tribunal to conduct remote hearings in the present dispute without providing substantial and sufficient reasons for the same. The counsel would also like to flag the concerns regarding confidentiality of the information that might be compromised. However, the tribunal needs to understand here that confidentiality of the proceedings is one of the major reasons why parties choose to resort to arbitration. And we contend here that remote hearings are not immune from cyber attacks, as in 2017, an arbitration dispute between China and Philippines was hacked by third parties. Now, I also request the tribunal to note the fact that in the past also, in the present case, leakage of information with respect to the condition of the sewage treatment plants has caused troubles to the respondent and in the country of Asgard, as massive protests had taken place. Therefore, these are the concerns that need to be taken into account by the tribunal before ruling on remote hearings, and the same was not done in the present case. And thus, we challenge the remote hearing decision of the tribunal. I shall now move to plead the second issue with respect to this issue. Apologies. I seek to establish that the tribunal cannot exercise its jurisdiction as the claimant has not complied with the mandatory pre-arbitral dispute escalation process. To begin with, I would like to state that the law applicable to this issue is the law of Asgard, which is in pari materia with the laws of India. And this position is supported by clause 26.1 of the EPC contract at page 17, which states, and if I may quote, that the EPC contract and any dispute or claim arising out of it in connection with it, or its subject matter or formation, including non-contractual disputes or claims, shall be governed by and construed in accordance with the laws of Asgard. Now, the counsel for the respondent submits that the test of ascertaining whether the arbitration clause in a particular contract is binding or not depends on the language of the clause itself. With respect to this, the Indian Supreme Court's decision in Oriental Insurance Company versus Narberam Power and Steel holds that the dispute resolution clauses must be construed and interpreted strictly, and the intention that the parties had in mind while signing the agreement must prevail. In light of this decision, the counsel for the respondent submits that if the clause contains the terms shall and must, then the same has to be understood as calling for a mandatory compliance with the pre-arbitral process. Now, for the present dispute at hand, I would like to draw the attention of the tribunal to clause 25.1 of the EPC contract, given in Annexure A at page number 1616 of the case study. And for the convenience, if the tribunal is with me here, then for the convenience of the tribunal, if I may read out the relevant part of the clause 25.1, it says, and I quote, any dispute based in contract or in law between the employer and the contractor arising out of or in connection with the EPC contract must be referred to their designated representatives for friendly discussions. It further says that if the dispute is not settled in these friendly discussions, clause 25.2 shall apply. Now, the counsel submits that by usage of the word must, the parties were obligated to first try to resolve the dispute by mutual discussions, and by usage of the word shall in the end of the clause, they were bound to resort to clause 25.2, that is the mediation clause, in the event that the discussions fail. Now, the tribunal may kindly note that clause 25.2 gave an opportunity to the parties to resolve their disputes via mediation. And this requirement, for the record, was also bypassed by the claimant. Therefore, the counsel for the respondent submits that the preconditions to the arbitration given under clause 25 were indeed mandatory for the parties to comply with before referring the matter to arbitration, and the claimant has failed to comply with the same. Now, the counsel also submits that, do I sense a concern?
If I can interrupt you briefly.
Yes,
how do you propose we look at the the term subject to clause 25.1 in clause 25.2, and in 25.3 the fact that it says either 25.1 or 25.2? How do you propose we look at that, and does that impact the argument you're making?
Mr. Arbitrator, for answering this question, I shall refer you back to clause 25.1, which first provides for a friendly discussion requirement for the parties to comply with. And towards the end of that clause, you shall notice that clause 25, it is mentioned that clause 25.2 shall apply if the dispute is not settled in these friendly discussions. Therefore, we submit here that first the parties were bound to comply with clause 25.1, and then if that fails, then the parties were bound to comply with the mediation requirement in clause 25.2. So here we need to read both the clauses jointly together. If I may proceed with my submissions.
So, counsel, sorry, I have a question for you.
Yes,
what's the law governing the arbitration agreement in this case?
Mr. Arbitrator, the law governing the arbitration agreement with respect to the jurisdiction issue is the law of Asgard, that is in parameter of the law of India, as clause 25 and as clause 26.1 clearly states that.
So the arbitration procedure will be governed by laws of India or Singapore?
Mr. Arbitrator, the procedural aspects of the arbitration shall be governed by the SIAC rules and the law of Singapore. However, the jurisdiction of the tribunal here is a pretty substantive issue which needs to be governed by the law of Asgard.
But why Singapore, you said? Just because it's SIAC rules and it's seated in Singapore?
Mr. Arbitrator, that is a different issue with respect to the procedure that the parties need to follow that the tribunal needs to follow for conducting the arbitration. Here, we're challenging the jurisdiction of the tribunal to hear the case.
Okay, sorry, I've still not got my answer. Okay, but why don't you proceed?
Thank you, Mr. Arbitrator.
Sorry,
asked. One is on your previous question. Would you agree that Rule 19 of the SIAC rule give tribunal the power to conduct virtual hearings?
Madam Arbitrator, I see that I've run out of time here. May I seek an extension of 3 minutes from the tribunal to answer the question and to also conclude my submissions? Yes. Apologies. Thank you, Madam Arbitrator. Yes, Madam Arbitrator, we agree with the point that Rule 19.1 grants tribunal the discretion to choose the law that is applicable to the arbitration and to conduct the hearings as per its discretion.
Okay. Secondly, on your clause 25, would you agree that 25.1 has been complied with?
No, Madam Arbitrator, it is a submission here that clause 25.1 has not been complied with by the claimants, as the discussion, as the term requiring friendly discussion, as the clause requiring friendly discussions cannot be satisfied by a few 2 or 3 emails exchanged between the parties.
But there was no response from you to the email of 24th April to further engage in discussion if you have the interest to either negotiate more or to want to mediate further. Is there anything on record to show that you intended otherwise?
Madam Arbitrator, as far as I can see, the mail dated 24th of April has been sent by the respondents, and in this mail we have clearly stated that, and if I may quote, let us continue to monitor the situation going forward and continue resolving any minor disagreements in this manner. This way we can avoid any contentious and formal dispute proceedings. To read this mail, we have indeed shown interest in trying to resolve the dispute amicably. However, it is the claimants who have not complied with the same.
So did you intend to have mediation? Have you proposed it anywhere in any of the correspondences?
Madam Arbitrator, we have not directly proposed mediation as an alternative dispute resolution mechanism. However, we have expressed our interest and our desire to explore alternatives and amicable solutions to resolve the dispute.
How would you have enforced 25.2 for how long? There's no timeline in 25.2. Assuming the mediation was to go forth, how long should that have continued in your manner?
Madam Arbitrator, with respect to that, it is my submission that mediation, the term mediation in itself is very clear, and therefore it clearly implies what steps that the parties need to follow. And considering that the present case is a long-term contract spanning over 55 months plus the extensions of time that have been granted by the both the parties, so prescribing deadlines for this particular mediation would be an unfeasible option. Thirdly, I would like to submit that there are mediation centers that specify the rules that govern the arbitration, that governs the mediation. So the term was pretty much clear in itself.
No, I haven't got your response. If there is no timeline to mediation, how would we be able to enforce it? I mean, would we indefinitely wait for parties to continue mediating? There's no mediation center rules that are applying here. This seems to be ad hoc mediation.
Yes, Madam Arbitrator, it depends on the discretion, and it depends on the agreement that the parties have reached when they start the mediation. However, it is a contention in the present case that the claimant has not even attempted to resort to mediation.
But there's been no offer from your side to mediate.
Yes, Madam Arbitrator, that is because the claimant has directly filed this case and referred this matter to arbitration before we could even resort to other alternative mechanisms to resolve the dispute. If I may just conclude in 30 seconds.
We're well out of time, maybe close to 5 minutes. So I think in the interest of fairness, we should perhaps end right.
Yes, Mr. Arbitrator. Shall I conclude?
We'll take it that you have concluded, please. Thank you. We can move on to the next.
Mr. Arbitrator. It was an honor arguing before the tribunal. Thank you.
Good evening to the Learned Tribunal. At the outset, can I just confirm if I'm adequately audible?
Yes, you are.
Learned Tribunal, I shall be mirroring the submissions made by my learned friend from the side of the respondents. And unless the Learned Tribunal has any preference with respect to the same, I shall be addressing the second issue with respect to how the present proceedings must be convened remotely first and then move on to the jurisdiction of this Learned Tribunal. May I do that?
Yes, please proceed. If we have a preference, we will interject. Otherwise, please proceed.
Most Learned Tribunal will firstly kindly notice that what I shall be trying to do in this regard is firstly I shall point out a logical fallacy with regards to the respondent's argument, and then I shall move on to prove how there is a legal fallacy as well. In this regard, firstly, may I kindly request the tribunal to take the first page of the statement of undisputed facts, wherein the memos of the parties have been adduced. And it states that the respondent is based in Beijing, Locat. Now, members of the tribunal will kind of appreciate that as of last month, there was a spike in COVID cases and there have been pseudo restrictions with respect to international travel to and from Beijing. So I do not understand how my learned friend from the other side comes up and proposes a physical arbitration in that sense. Be that as it may, my learned friend pointed out that Rule 19.1 mandated that the tribunal will be taken into consideration or will be consulting the parties before making any procedural orders. However, that is one of the aspects. Even if that may be the primary aspect, members will kindly note that in paragraph 37, that was the first procedural order. And in paragraph 37 and 36, it has been reproduced that the parties were consulted. When the mode is changed in paragraph 45, that is on 31st January 2022, what is essentially happening is that the procedural order is revised. So a revision is taking place. Now, the SIAC, under the SIAC rules, Rule 19.5 essentially deals with the aspect of revision. And may I kindly request the members of the tribunal to take up Rule 19.5 in this regard. And for the assistance of the tribunal, I shall read it out also. Unless otherwise agreed by the parties, the presiding arbitrator may make procedural rulings alone, subject to revision by the tribunal. Now, under Rule 19.5, members of the tribunal will appreciate that there is no aspect or an obligation upon the tribunal to consult the parties. And it is purely, again, may I kindly request the tribunal to take note of paragraph 37 in page number 12 of the Statement of Undisputed Facts, wherein in point 2, the intention of the tribunal was also to conduct the arbitration as expeditiously as possible. Members will kindly note that this arbitration was supposed to be taken place on 18th to 29th May last year. We are already delayed by one whole year. The very requirement of an arbitration is that it is a speedy recourse or speedy disposal of disputes. We are already 1 year delayed. So it is against the interests of expediency, which is one of the factors under 19.1 also, that the arbitrations be convened physically. Secondly, my learned friend had also raised a point with respect to due process concerns. Now, learned arbitrators will kindly appreciate that the Singapore International Arbitration Center had come out with a set of guidelines which shall be assisting remote arbitrations in that sense in August 2020, titled Taking Your Arbitrations Remote, wherein there are clauses therein. And with respect to concerns of due procedure, the general issues to consider with respect to witness testimony, evidence, and opportunity to parties have been considered as to how these aspects shall be dealt with in remote arbitrations. Further, even under the unsettled model law, the right to be heard is not an absolute right. It is subject to reasonableness. Now, over here, firstly, learned arbitrators will kindly appreciate that the entirety of the disputes have not yet been heard. Today, I am arguing before this tribunal, and the tribunal is giving me an opportunity, as an opportunity has also been provided to my learned friend from the other side. What essentially crops up as a possible hindrance is certain technical hiccups or with the aspect of voluminous evidence, which the tribunal had considered previously with respect to rendering its reconsideration application also. But again, in this regard, question 6, 20, and section K of this particular SIAC guidelines with respect to remote arbitrations take care of these concerns and adduce possibilities as to what measures might be taken by A, the parties, and B, the tribunal to take note of, to balance these particular factors. Thirdly, my learned friend had raised an issue of confidentiality. Now, I would like to address this again.
Before we move to confidentiality, we asked a similar question to your colleague on the other side. How do you perceive the issue of virtual hearings? Do you see it as a procedural irregularity? You are today arguing on behalf of the claimant, but were you to what is your appreciation of the point that you're seeking to meet? Is it a violation of a right to a hearing physically, or do you see it as a procedural irregularity?
Mr. Arbitrator, I shall answer your question taking recourse to a question which learned arbitrator Mr. Jain had asked my learned friend from the other side, that what is the essential aspect over here? The law which is governing the procedure is not the International Arbitration Act of Singapore or the Singapore Arbitration Act of 2001. It is the SIAC rules. Now, the SIAC rules do not espouse any such right to be heard physically. So, in the absence of the same, and if Mr. Arbitrator also peruses Rule 24 of the SIAC rules, there is also no explicit bar to hearing these particular disputes remotely. Now, that is a legal answer. Now, Mr. Arbitrator, also to answer your question logically and practically, SIAC as an institution has been successfully convening remote arbitrations through the past 2 years.
Can I interrupt, because I'm not sure that you're answering the question as I understood it, and I want to ask you this question very directly. Putting aside the question of whether or not we have the right to order a remote hearing, which is where I think you're going, have we violated our obligations by doing so without consulting with the parties, as the respondent has argued? What is the answer? I understood that the respondent was arguing a procedural irregularity, and you seem to have jumped over that to the substance of whether or not there was a right or wrong. What is your case as to why we have not committed a procedural irregularity?
Yeah, and before you answer, sorry, just an additional question in terms of what Stephen asked. Will you not be risking the enforcement and challenge of the award, right? If this issue is if it's not adjudicated in terms of what the respondents are arguing, wouldn't this be a big challenge to the enforcement?
I understand your concern, Mr. Arbitrator. May I kindly address Mr. Finizzo's query first and then come to you, Mr. Jain? Most certainly. Now, to answer Mr. Arbitrator's issue with respect to how it's a procedural irregularity or not, right at the inception of my submissions, I had stated out as to how Rule 19.1 firstly does not mandate that consultation with the parties is the only aspect which needs to be taken into account. Now, in paragraph 34 of the statement of undisputed, I beg your pardon, paragraph 36 of the statement of undisputed facts reproduced in page number 12, essentially states that the parties had been consulted before passing the first procedural order. Now, once the first procedural order has been passed, any revision in that order is a revision and not passing a new order altogether. So, with respect to a revision in the order, what essentially incorporates into mandate is Rule 19.5. Now, Rule 19.5 with respect to revision does not mandate consultation with the parties, even in the remotest way. Thereby, it is not a procedural concern.
So I don't intend to interrupt you, but are you saying, therefore, the consultation is mandatory? That's what you just said. Is that what your case is?
Mr. Arbitrator, what I said, that consultation is one of the aspects that needs to be kept in mind while passing the first procedural order as per Rule 19.1. When there is a revision in this order as per Rule 19.5, there is no obligation, even in the remotest sense, to consult to the parties. And in that regard, may I also answer Mr. Arbitrator's question with respect to the enforcement of the award? Section 48, subsection 1, clause D of the Arbitration and Conciliation Act 1996 essentially does away with the execution of an award if there are any procedural irregularities, unless otherwise agreed to by the parties. Now, here, as I have already submitted, there is no procedural irregularity. Therefore, the question of setting aside the award at a later stage by a court does not come into picture. Have I addressed both the arbitrator's queries adequately?
So I'm not sure what your answer to Mr. Jain's question was. So there is a requirement, but we met that requirement because we did it once, so we don't need to do it again. Is that the position?
Learned arbitrator, Mr. Kapoor, the position is that once a procedural order has been rendered, when it is revised, may I kindly request Mr. Kapoor to take up Rule 19.5 of the SIAC rules? And if Mr. Arbitrator is with me, I shall proceed. And I shall read out. Rule 19.5 states that unless otherwise agreed by the parties, the presiding arbitrator may make procedural rulings alone, subject to revision by the tribunal. So this is the sole, it is the sole power of the tribunal and does not mandate consultation with the parties. Have I answered the question adequately? Thirdly, with respect to the aspect of confidentiality as raised by my learned friend, again, learned arbitrators, the SIAC rules with respect to remote hearings address this issue. Question 16 of the specific queries essentially state that the overall confidentiality and data security has to be enforced by both the parties and the tribunal, and also a platform offered by the Maxwell chambers has been offered in this regard, which the parties might where the parties might convene the remote proceedings, and the aspects of data security and breach won't arise. SIAC has been doing remote arbitrations for the past 2 years, and such an issue has not arisen in the past 2 years. So I don't see how that becomes a valid issue now, given that there are guidelines on this particular aspect. To buttress my argument in this regard with respect to a procedural irregularity, may I also state that in the judgment of China Machines New Energy Corporations versus Jaguar Energy Guatemala in paragraph 143, it has been stated by the Singapore Court of Appeals that due process concerns cannot be misplaced to accommodate procedural orders with respect to something as grave as the current one, wherein one of the arbitrators have fallen prey to COVID, even though her symptoms may have been mild. And in Anil Singh Gurum versus JSA, again a judgment rendered in 2020 by the Singapore Court of Appeals in paragraph 73, aspects like voluminous evidences, witness testimony, and these aspects cannot be taken to be due process to be encumbrances or problems with respect to due process, as the right to be heard is supposed to be balanced against other rights, as has been acknowledged by the tribunal in this regard in paragraph 37.2, wherein it is also the intention to carry out the process expeditiously. In that regard, if the tribunal does not have any preliminary issues on the issues with respect to the mode of convening the proceeding, I shall address the issue with respect to the jurisdiction of the tribunal.
Just one question. How do we address the confidentiality concern of the other side?
Most certainly. Madam Arbitrator, as has already been submitted by me, there are two aspects that bring out issues regarding to confidentiality. One is we know that if there is not a safe platform or a protected platform over which such arbitration is taking place, so of course hacking or data leaks might take place. Under question 3 of the FAQs on the official website of the SIAC, the guidelines, FAQs with respect to remote proceedings, it has been stated that the Maxwell Chambers offers a platform that shall be taking care of these issues of confidentiality in regard. Second, under the SIAC guidelines of 2020, August 2020, general issues to consider number 16, confidentiality and data security. It must be noted that it is the endeavor of not only both the parties, but also the tribunal will be exercising such powers to ensure that data security and cybersecurity is not compromised. And there are adequate guidelines in this regard. In light of the same, there cannot be any confidentiality issues. Have I answered Madam Arbitrator's question in adequacy?
Yes,
Much
please.
obliged. So can I move on to my issue with respect to the jurisdiction of the tribunal?
To me.
Yes, you may.
Learned arbitrators, it is my contention with respect to the jurisdiction of the tribunal and how the same is not unhindered, essentially because now, as has been pointed out earlier also, that the standards with respect to how whether the pre-procedural obligations have been met or not shall be the standards that have been espoused by the law of Asgard or the law of India. In this regard, with respect to pre-procedural obligations, and firstly, I shall draw a general paraphrase in this regard, wherein the Honorable High Court at Delhi, while adjudicating a similar clause where the mediation procedure was not described, had rendered the same unenforceable. And this also is the same with respect to friendly discussions clause. However, I shall be addressing that in specificity later on. In this regard, may I kindly request the learned tribunal to take up paragraph 7, Arabic page number 2 of the memorandum submitted on behalf of the claimants, wherein the position across jurisdictions in the world have rendered the following considerations to be completely fulfilled to render a mediation clause enforceable. Firstly, there must be a mandate to mediate. Now, I shall be addressing this. I shall be addressing this. Before that, there must also be a process that must be adequately described, a procedure for the selection of the mediator and his remuneration, and a time frame that must be levied in this regard. In the absence of the same, this particular mediation clause is unenforceable. Also, with respect to there being a mandate, albeit in paragraphs 21, in clause 25.1 of the EPC contract, the language used is that clause 25.2 shall be applied in the last line. However, when we come to clause 25.3 of the EPC contract, which is essentially the power to refer the dispute to arbitrations, this becomes an optional clause because of the wording that if it is not resolved pursuant to either 25.1 or 25.2. In this regard, both these obligations may not be confirmed. Now, this essentially brings me to the aspect of friendly negotiations. While in Annexure C, which has been reproduced in pages 23 to 26 of the memorandum of the Statement of Undisputed Facts, a perusal of the same would reveal that while the answer to the invocation of force majeure on 20th April 2020 essentially states that the invocation of force majeure is improper, the response to the same is not suggesting any alternative means, but simply stating as to how no, that it would be applicable. This is essentially propounding that there are two polar stances taken by both the parties. When this is the scenario, and the prior conduct of the parties are such, then the mediation clause would not be rendered fruitful. And in Demera Distilleries versus Demera in Demera Industries, a judgment rendered by the Indian Supreme Court in 2015 had stated the prior conduct of the parties rendering mediation unsuccessful would essentially lead to the mediation clause being unenforceable. The same goes with regard to the aspect of friendly discussion. I see Mr. President has a question.
No, I wanted to draw your attention to this enforceability of the mediation clause. Would you agree that this tribunal has a duty to encourage parties to resolve their disputes amicably? Would you agree with that proposition? And is there anything in conflict with that with the SIAC rules?
No, Mr. Arbitrator.
Okay, if you do agree with that, then would you then not agree that it is perhaps even at this stage, again, for the reasons mentioned by Mr. Jain, my colleague, for the safe and secure enforceability of the ultimate award, that we should consider perhaps refraining from proceeding with this arbitration for parties to continue mediation and then come back? Would you not think that that is a procedure that should be adopted?
Mr. Arbitrator, seeing that I just have 1 minute left, may I kindly ask for an extension of 3 minutes and answer your question and then sum up this particular issue? Much obliged. Learned Arbitrator, what you are essentially suggesting is that the parties now go back to mediation. Now, Learned Arbitrator, with utmost respect, an arbitral tribunal is confined with respect to its powers by the contract by virtue of which the tribunal has been constituted. Under the contract, what is mediation has not been described. The time period has not been described. So how will this learned tribunal order me to go back to a procedure called mediation? And then what will be the time frame for which I have to adhere to such mediation? Who will be the mediator? These questions must be essentially answered by the contract. And when the same is not answered by the contract, it would be beyond the scope of the tribunal to traverse beyond the contract and ask me to go back to mediation. Have I answered Mr. Arbitrator's question in adequacy?
In part, you did not reflect on the issue, the impact on the enforceability of the award. And I would invite your comment on that. But since your time is limited, you might proceed to conclude your argument as well.
Sorry, I have a couple of questions on this point. So, Mr. Counsel, are you not in breach of clause 25.1 by, on your own, assuming that it is not enforceable? right? That is, and of course, you have explained why, why is that the mediation was not proper, right? You have not taken any steps whatsoever to even propose timelines, let's say even 2 weeks, 3 weeks on your own, or to propose a name of the mediator, right? Given that this is all being governed under SIAC, I'm sure you are aware about the AMA protocol, right? I don't think you'll find any clause where the mediator's name will be mentioned, right? It is always to be agreed by the parties, right? And there are various rules, including the AMA protocol, which lays down the timelines in terms of what is the timeline for the purpose of mediation. So even if the clause is silent, there are rules to provide for it, right? So given these points, are you not in breach of clause 25.1? And then I have a follow-up question, but why don't you answer this first?
Mr. Arbitrator, do I answer Mr. Jayasima's question just with respect to the enforcement part first and then come to your query? Mr. President,
Mr. Jain's question comes, it's more pertinent and immediate. So please answer that and then you can answer that.
Definitely. Mr. Arbitrator, subject to correction, the interpretation of clause 25.2 or 25.1 or the standards associated therein to meet the same shall be Indian law and not the SIAC rules or the AMA protocol. It is only the arbitration proceedings that shall be governed by the SIAC rules. Further, with respect to clause 25.1, may I point out that the parties have already endeavored to come into friendly discussions through the email exchanges in Annexure C. The standard is that there must be an honest and sincere attempt, which has been espoused in paragraph 52 of...
I'm slightly confused, and even the respondent couldn't answer this question, but let me just, what is the law governing the arbitration agreement? As far as this present case is concerned, of course, the law governing the substantive contract is the Indian law, but which is the law that governs the arbitration agreement? I mean, it's a fairly simple question, but I've not got the answer so far.
May I kindly direct Mr. Arbitrator to Annexure A, clause 26.1, which states, and a perusal of the same would reveal that the law governing the arbitration agreement is the law of Asgard, that is India. It is just the Courier law, which is not even the law of Singapore, but the SIAC rules in specificity.
Are you aware there's a difference between law governing the arbitration agreement and law governing the contract, the substantive contract? So just to simplify it further, what is the law governing the EPC contract and what is the law governing clause 25?
Okay. Learned Arbitrator, since the parties have been silent with respect to what shall be the law governing clause 25 exclusively, since clause 25 also forms part of the EPC contract, the general interpretation will be that the law of Asgard will be taken recourse to interpret the same, subject to correction.
What is the seat of the arbitration?
Learned Arbitrator, the seat is Singapore.
Yeah, and what is the Singapore law position? If the clause is silent, then which is the law that will govern the arbitration process, the arbitration agreement? And I want respondent also to answer this at some stage.
Most certainly, Learned Arbitrator, I think so. I may have stretched down the wrong path over here, because I have a judgment to that effect which says that the seat will essentially be the law governing the arbitration agreement, and I correct my position in that regard.
So then what is your position now? Is this the law of India or is it law of Singapore?
Learned Arbitrator, it is the law of Singapore. However, what I have put forth in my submissions, I have tried to draw inspiration from jurisprudence or from jurisdictions across the world in this regard, and more or less, and not more or less, almost
I don't think we need to refer to the jurisprudence across the globe. I think, I mean, if you're limited to Singapore, India, we should just focus, and I think the position would be clear. Are you aware about the English case of Enka and Kebabji?
Enka versus Chuk.
Yeah, that's the one.
Enka versus Chuk.
Yeah.
Yes.
What is it?
Learned Arbitrator, yes, Learned Arbitrator, while it has been held that mediation clauses would be enforceable in the said case, however, subject to correction, in paragraph 7, the said mediation clause had been reproduced. Over there was a time period of 4 weeks ascribed to the said clause, because of which was one of the considerations the England and Wales High Court took into consideration to enforce that particular clause, which is not the same here. And with respect to clause 25.1, which is friendly discussion, we have already complied with the same. And that is exactly vociferating our position as to how the parties are still on
What
polar
is the
standard.
law laid down in NCA's case in relation to which law will govern the arbitration agreement?
It will be the law of the seat.
Okay.
Because the challenge was the word disputes in the clause therein. And the words disputes have been interpreted upon, and subject to correction and the council's understanding, it was the law of the seat that would be governing the clause.
Okay, I'm good. You can continue. Thanks.
Learned arbitrator,
well out of time. I think in the interest of how much time we give to the other side, we should perhaps stop at this stage.
I think so. I have adequately
Move on
addressed
to the
all
next
points.
Thank you. Counsel for the respondent.
Am I perfectly audible and visible?
Oh, sorry, Claimant. Yes.
Good evening, members of the tribunal. This is the counsel for the claimants, and I'll be dealing with the issues on merit. That are the issues related to liquidated damages, specific performance, and breach of contract. I'll be first addressing the issue of breach of contract through principles and facts, and then would proceed to address the issues on force majeure clause and specific performance. If that is fine with the members, I may proceed.
Yes,
so,
please.
Regarding the first issue at hand, which is breach of contract, the claimants in the present case contend that the respondents are in breach of contract, and this would be stipulated through a perusal of the EPC contract as well as later judgments. A perusal of clause 10.1.
Can we have the video of speaker 1 for respondent on, please? Okay, maybe somebody can just communicate to him and you can proceed.
For the purpose of proving breach of contract, I would like to attract the members' attention to clause 10.1 of the EPC contract when read in consonance with clause 26.2 of the same contract. For the convenience of the members, I may read the clause as the contractor can apply to the employer for an extension of time for completion of the project by way of notice if the contract is delayed or impeded, so on and so forth. The 10.2 lays down further conditions, which is within 10 days from the date of receipt of the EOT notice by the employer. If the employer agrees to the request for the extension of time, the procedure for amendment under 26.2 would follow. Now, in this regard, clause 26.2 of the EPC contract essentially says that amendment would take place in the form of a written amendment agreement between the parties by the authorized representatives of the parties. Now, a perusal of statement of undisputed facts for the design phase being paragraphs 8 to 12 of the statement of undisputed facts, the same would reveal in paragraph number 11 that when an extension for the design phase is sought by the contractor, are the members with me on statement of undisputed facts? Paragraph number 11, page 5 of the statement of undisputed facts. Therefore, when...
Counsel, please avoid rhetorical questions. Please continue.
Indeed. Paragraph number 11 stipulates the extension of time, the alleged extension of time that the respondent sought in the present design phase. It has been produced in that particular paragraph that to extend the design, it was understood that the employer had agreed to extend the design phase of the project by more than 3 months, and in turn also extend the procurement phase and the refurbishment phase by at least 4 months. Now, in this regard, I will put forth that this extension, which is sought by the respondents in the design phase, is not in the nature of seeking an agreement or a request, which the EOT notice pre-requires, but is a direction in this regard. Against this, in the Supreme Court of India judgment, Arosan Enterprises versus Union of India, paragraph number 13, it has been held by the court that there cannot be any presumptive extension of time
and any extension of time should be categorical in nature. So the employer, having not assessed the situation and not replied to the contractor in the present case, there is no amendment to the agreement under clause 26.2 of the EPC contract. Now, as a preemptive answer to the delay caused by the employer, I would like to put forth the situation in perspective regarding the prevention principle. Now, for the perusal and the convenience of the tribunal, a presumption principle which was first laid down as Home versus Guppy, England and South Wales court judgment, that when an employer does something which delays the performance of the contractor, then in such case, the employer cannot seek liquidated damages. However, this has been held to be an orthodox approach, and this has been changed in the subsequent judgments, including the judgment of the Supreme Court of New South Wales, Turner Corporation Private Limited versus Ostotal Private Limited, a 1994 judgment, when it was first overturned. Now, the present situation of the prevention principle operates as that when an extension of time clause has been given in the contract, it is the duty of the contractor to apply for such extension of time, even if the delay is caused by the employer. And in that regard, the employer can still seek liquidated damages if the contractor has not availed their duty in the correct manner. Now, in this sense, the contractor, though through a directive mail, allegedly applied for the EOT notice, the proper procedure under clause 10.1 was not followed. Now, this EOT notice procedure is mandatory in the present respect, because in the judgment which the council referred, Turner Corporation was also referred to in the subsequent judgment of England and Wales High Court in Multiplex Constructions versus Honeywell Control, in which it was held that notice, the procedure of notice being served, seeks mandates, because notice provides an opportunity to the other party to assess the situation at hand, see if the party seeking for such extension is justified in seeking such extension, and then reply to such a request for extension with an agreement. In this case, the employer has not been provided with the opportunity, being the notice served through a mode which was not agreed upon by the parties, and therefore the EOT notice procedure having not been followed in the design phase, and the contractor having no recourse to the prevention principle, the liquidated damages can be sought, given that the design phase has been extended by a period of 3.5 months in total.
Can I interrupt you for a second and ask, I understand your argument about the failure to follow the formal notice requirement, but then you went on to say that meant there was not an opportunity to consider. the employer was notified though, right? So are you telling us, I want to make sure I understand your argument. Is it that there really was no opportunity, or was it that the formal failure is sufficient to justify your position?
Mr. Arbitrator, I would also like to attract your attention to clause 26.3 of the EPC contract. In this clause, it is given that any notice, demand, or offer, or any other written instrument required or permitted to be given shall be in writing, signed by the party.
I understand that you're saying that didn't happen, but you also went on to say that meant you didn't have the opportunity to consider the position. You were notified though, as a practical matter, correct? Your client was notified. So I need to understand, is your argument that the mere failure to comply with the formal requirement is sufficient? Because you spent a lot of time telling us about what the underlying principle was, but I take it that you don't care about the underlying principle, because in fact here there was an opportunity for your client to consider this, but you're relying entirely on the breach of the formal requirement.
Mr. Arbitrator, when parties to an agreement have agreed upon a particular procedure to be followed, given in respect of certain notices or demands, the employer in the present case cannot be expected to reply to that email, which is again reiterating that it is a directive email and not even seeking a request.
Okay, so the short answer is yes, you're relying on the formal requirement, and the fact whether or not your client got the benefit of notice in reality is irrelevant to your position.
Mr. Arbitrator, again, we didn't get the benefit of the notice in the present case, because we having not known that they would be serving the EOT notice on a platform that was not agreed upon by the parties. So we cannot be expected to respond to that.
Are you telling us that you did not get notice as a practical matter, or are you telling us you did not get notice as it was defined under the contract?
Mr. Arbitrator, I'll assess the situations in twofold manner. The first being that given that the facts are silent about any reply or acknowledgement of the email, the first contention would be that we didn't notice the EOT notice being sent. Secondly, even if we did acknowledge the email, we were not bound to respond to that email given that a process has been agreed upon between the parties. And it is no obligation upon the employer to inform the contractor that you have to follow the procedure at hand because the parties are competent.
I understand. Thank you.
As a quick follow-up to that, do you not see a contradiction between your suggestion of a strict interpretation of a notice requirement for supporting your argument currently and your colleague's argument a few minutes ago asking us to ignore the formal requirements of the pre-dispute resolution process? Do you see a contradiction?
Mr. Arbitrator, the issue that my co-counsel was dealing with this procedural issue, and the interpretation of shall in that procedural issue is according to the procedural norms. However, what the counsel is claiming is the general understanding of the word shall, and it is supported that the substantial issues in this regard can be differentiated from the procedural issues. So therefore, my co-counsel's submission on interpretation of shall would not be of any relevance or any contradiction in my submission of the usage of word shall. Have I answered?
Do you have any legal authority to support that proposition that the use of the word shall in procedural matters is different from the use of the word shall in substantive matters?
Mr. Arbitrator, with the very essence of the word shall, and there's always a conflict between may being construed as shall or shall being construed as may.
No, my question was, is there a legal authority for the proposition? That's all.
The counsel is not aware of the legal authority presently, so it will.
You can proceed. You can proceed.
Yes, I would depend on the general interpretation of the contract. In this regard, the counsel would now move on to the procurement phase, again in which the EOT notice procedure was not followed. A perusal of paragraphs 18 to 21 of the this counsel stands directed, 13 to 16 of the statement of undisputed facts relates to the procurement phase. Now, in the procurement phase, again, on 1st March through the email dated 1st March 2019, which is Annexure B, page number 4, the respondents in the present case have again directed for an extension of time, and the employer did not agree for such extension. Then the respondents also claim that through the minutes of meeting, which a perusal of paragraph number 16 of the statement of undisputed facts would reveal, that a minutes of meeting was conducted between the respondents and the claimants. And in that particular meeting, it was agreed between the parties that an extension of 5 months would be given. However, it has to be noted that this decision in the minutes meeting was recorded by the contractor's representative and sent through an email. Now, this email again was not acknowledged by the employer in the present case. However, be that as it may, minutes of meeting, the law of minutes of meeting generally corresponds that a minutes of meeting, when not in contradiction with the contractual clauses, can operate as a written agreement. However, it has also been held in MCI Telecommunications Corporations, which is a Court of Appeals of Minnesota judgment, again a common law jurisdiction, that minutes of meeting cannot be construed as an agreement because the written records of the minutes of meeting mainly relate to the discussions in the meeting. And such record in the minutes of meeting does not liberate the parties to a contract to follow the procedure, official procedure afterwards. So therefore, this minutes of the meeting under paragraph number 16 does not constitute to be a written amendment to the contract in any respect of the revised timelines. And therefore, again, an extension of time, a delay in performance of the contract can be witnessed in the procurement phase. With this respect, the claimant in the present case is seeking damages for the design phase as well as the procurement phase. That being the issues related to liquidated damages and breach of contract, I would be moving to the next issue of force majeure clause and invocation of force majeure clause in the present case.
Sorry, I have a question. So assuming the clause 10, which is extension of time, was not there, right? Then would the exchange of emails on 1st and 3rd March, would those exchange constitute sort of an agreement revising the timelines?
Mr. Arbitrator, in the absence of a comprehensive procedure for EOT notice, the emails sent on 1st March and 3rd March would be operative as extension of time, given that they would have sought the very essence of the construction contracts is that time is the essence, in which employer is given the opportunity to assess the situation and grant the contractor with extension of time. Even if the extension of time clause was not present in the contract, the very language of the email, if not a directive in nature, but seeking request or seeking extension of time subjected to the permission of the employer, it would have been an operable extension of time.
Right. So you acknowledging the email that which is on 1st March and complaining that there has already been huge delay, would you say that that email of yours, acknowledging the email of 1st, will constitute your conduct to show that you revised and that you accepted the revised timelines?
No, Mr. Arbitrator, since I've already stipulated that there's no presumptive extension of time, and since our contract also says that a procedure under 26.2 related to the amendment of the contract has to take place, the mere acknowledgement of the email would not suffice the agreement of the employer in this regard, and substantially the written amendment agreement which is required by the EPC contract.
Thank you.
But you did not register protest in any of the emails, did you?
Sorry, Madam Arbitrator.
To suggest otherwise, that when they asked for extension or they sought time, did you oppose it? Is there any correspondence from your side to suggest that?
Madam Arbitrator, the claimants and the respondents are two competent parties that have entered into the contract, and the terms of the EPC contract were not only agreed to by the claimants but also by the respondents. In such a scenario, the employer is not in a position to spoon feed the contractor regarding the procedure that needs to be followed on the EPC contract. The respondents, being a competent party to the contract themselves, they should have taken care of the procedure. And again, it is not a responsibility on our part to remind them that the procedure has to be followed.
Explain that to me. If we were to find that you were effectively notified, irrespective of, it coming in the form of notice or not, but you were effectively aware that there was this thing, how you supposing we look at the wider issue of extension of time? Should we allow it? Should we not allow it? What is your position?
Mr. Arbitrator, as I've already answered the question regarding that we being notified and we being in agreement of the extension of time are two separate things to be considered. However, regarding extension of time, had the contractor followed the extension of time procedure validly, then the claimants in the present case could have considered the situation, assessed the situation, and in their very good faith could have granted extension of time. But since they didn't even seek for an extension of time in a valid manner, such extension of time cannot be permitted under the EPC contract. If that answers, Mr. Arbitrator,
Okay.
The council would now be moving to the force majeure clause. The first submission in this regard, the respondents of present case claim that they have invoked the force majeure clause in a valid manner, and they are seeking this force majeure clause in relation to the refurbishment phase of the EPC contract. However, for the very first submission, it is rendered that force majeure clause in the present case is exhaustive in nature. Now, a perusal of again 9.1, clause 9.1 of the EPC contract, which though begins with that it shall mean any event, circumstance, or combination of event directly or indirectly, and so on and so forth, stipulating the conditions, is restrictive in nature by the very usage of the words that force majeure events can be natural or non-natural as per the below. The phrase as per the below restricts the ambit of the definition which was provided at the very beginning of the contract. Now, since it is already mentioned that there would be natural or non-natural events, such natural and non-natural events have been listed again in the EPC contract. And the natural force majeure events, acts of God being drought, fire, and explosion, volcanic eruption, and such other instances have been mentioned to which the force majeure clause would apply. Now, this principle of force majeure clause being interpreted narrowly has been borrowed from the Indian Supreme Court judgment of Energy Watchdog versus Central Electricity, which is a 2017 judgment, which was also reiterated in Halliburton Offshore Services Limited by the Indian Supreme Court in 2020. Be that as it may, regarding the exhaustive nature of the force majeure clause, the invocation procedure under clause 9.2 of the EPC contract has still not been followed. This 9.2, for the convenience of the tribunal, says that the affected party shall give notice in writing of any event of force majeure to the other party as soon as reasonably practicable. And last third line of the same clause saying that such notice shall include full particulars of the event, its effects on the affected party, the concessions, and the remedial measures proposed. Now, in this case, the council would take a preemptive view that even if, given the pandemic condition, the claimant in the present case let go of notice being in writing, again, the notice should encompass all the other particulars that are required under this notice. Now, a perusal of the email dated 23rd March 2020, which was sent by the respondents in regard of invocation of force majeure clause, would reveal that though they've said that COVID-19 is invoked as force majeure, they've not mentioned the effects it would have on the other party. To read the email, they only mention that we are invoking clause 9 of the EPC contract on grounds of force majeure arising out of disruptions caused by the COVID-19 virus. Now,
pausing for a moment, is not the pandemic a event which by definition has unforeseen consequences, which cannot be precisely foreseen, especially at the start of the pandemic?
Mr. Arbitrator, by that very reason, the council has additional submissions in this regard, that the invocation of force majeure not being in a valid manner, and also as the council would be submitting in her further arguments that the basis on which such force majeure event was invoked also does not make it a valid invocation of force majeure. So therefore, in totality, to view the circumstances in entirety, the respondents cannot invoke force majeure. Now, addition to the...
Again, I mean, you may proceed, but just that my point hasn't been reflected upon. The nature of the force majeure event happens to be a pandemic. It's not a fire, it's not a flood, it's not anything else. So since it is this, and since we've now all experienced the pandemic, is it not reasonable in your view that the precise effects of the pandemic were largely unforeseen, especially at its infancy?
Seeing that I'm running out of time, can I request an extension of 3 minutes?
Yes, but you may proceed quickly with that.
Yes, Mr. Arbitrator, as you rightly pointed out, that COVID was an unforeseen event. So therefore, in this respect, I'm submitting that even if the exhaustive nature of the force majeure clause is not taken into consideration, the facts of the case would reveal that the respondent, particularly the respondent, would not be entitled to invoking this force majeure clause. Even if we recognize pandemic as a force majeure event, they are not entitled to invoke this force majeure event. Now, having not complied with the requirements under 9.2, when in a subsequent email dated 24th April 2020, they did mention the reasons for invoking. These reasons were stipulated as supply chain and labor disruptions. Now, regarding labor disruptions, attention is brought to paragraph number 25 of the EPC, of the Statement of Undisputed Facts. Paragraph 25, page number 8 of the Statement of Undisputed Facts, line number 9, in which it has been said that the contractor had proactively arranged for the safe return of laborers from mid-March onwards. Since the Asgardian government was unlikely to protect their interests, also it is given that they gave them sustenance and compensation for a year on the ground that their services would not be needed for at least a year. So, Mr. Arbitrator, members of the tribunal, in this present case, the respondents, in a mere anticipation of force majeure clause of the COVID pandemic, because till mid-March 2020, the national lockdown was still not in operation, they sent their laborers back to their hometowns and gave them compensation and also told them that their services would not be required for at least an year. Now, in this case, if attention is brought to paragraph number 38 of the Statement of Undisputed Facts, the refurbishment phase suffered as a consequence, in which the lockdown having been completely lifted by 31st October 2020, the work of the refurbishment phase could not resume until January 10, 2021. So there's an elapse of 2 months and 10 days because there was no labor present, having the respondents send them back to their homes. So therefore,
Can I interrupt to make sure that, because I want to not extend your time much, but when you say you preceded that whole discussion of the facts by saying that your position was that even if a pandemic is a force majeure event, here there was no entitlement to invoke force majeure. And is your reason because of the disconnect between the timing between releasing the workers and when lockdown was lifted? Is this why you say there is no entitlement?
Mr. Arbitrator, the very essence of force, shall I seek an extension of 1 minute to sum up?
Why don't you just finish answering my question and then we'll let the president decide. Just
Indeed.
quickly, we're talking too much about the process. Answer my question quickly.
Indeed, Mr. Arbitrator, what the council is seeking in this present regard is that even if force majeure is recorded as a pandemic is recorded as force majeure event, the very essence of force majeure is that it renders the performance of the contract impossible. Now, when the contractor himself has imposed hardship upon themselves, they cannot seek remissions from the employer for such hardship being imposed.
Okay, understand.
So,
thank you.
Yes. In this regard, I would be just concluding with the relief of specific performance. This contract being of national importance.
You can just take a minute to conclude, please. Thank you.
Indeed, Mr. President. For the argument of relief of specific performance, it is put forth that since the present project is of national importance, given it is related to sewage treatment plants on River Hastrat, which serves for the livelihood of 70% of the population, as produced in paragraph number 1 of the Statement of Undisputed Facts, monetary compensation would not be the only adequate relief in this regard, and therefore specific performance of the present contract ceased relevance. And since the employer in the present case is not barred by sections 11, 14, and 16 of the Specific Relief Act, such specific performance may validly be granted to the employer. That's it. It was an honor.
Can we hear now from the respondent, please?
Indeed. If I could clarify that I'm audible, visible, everything.
Not everything, but the other two, yes.
My apologies, Mr. Arbitrator. I'll begin. Good evening, members of the tribunal. I am the co-counsel representing the respondent in today's proceedings, and I seek to establish before this tribunal two major key aspects of our case with respect to substantive issues. These are firstly that the respondent has not breached the EPC contract, and secondly that the claimant is not entitled to the claimed remedies in the present matter. Before I begin with my submissions, there was a question posed to my co-counsel by Mr. Jain, which was regarding the law governing the arbitration agreement. And it was asked of me by my co-counsel that I clarify the same again, which is that the law governing the arbitration agreement is separate from the law governing the substantive issues, is our agreement, is our submission as well. But in an absence of a contrary indica, which is an indication to the contrary, it is the law governing substantial issues of the contract itself, which also govern the substantial issues of the arbitration agreement. And this was held in Sumitomo Heavy Industries Limited versus Oil and Natural Gas Commission. If I may proceed with the substantive issues, if the same is all right.
Sorry, I don't want to interrupt, but just to clarify, so are you saying therefore the law governing the arbitration agreement is the Indian law, which governs the main contract?
If I may allow my co-counsel to take this up in when he is giving his rebuttals.
So why don't you finish up and then we'll see.
For sure. So if I may move back to my first proposition, which was respect to tribunal, that the claimant in the present matter has claimed that we have made a breach of contract on account of delays in the various stages of performance. The respondent, however, has not delayed performance at any stage, is our submission. And this is because, firstly, there was a valid extension of time given to the claimant with respect to the design and procurement phase. And secondly, that the postponements in performance of the refurbishment stage do not amount to a delay or breach because the force majeure clause was indeed validly invoked. And I'll be following the same order as that was what was followed by my opposing counsel. Moving to my first submission, I submit that an extension of time had indeed been granted. And for the same members of the tribunal, we understand that although the design and procurement phases were to be executed within 6 and 12 months respectively from the letter of award, Delays on part of the employer led to revisions in these timelines, as was agreed upon by the employer through the email dated 3rd March 2019. This was their admission as well. It is per these timelines that the work was hereon completed. Accordingly, respective tribunal, it is submitted that the revisions made through the email, even though it was made through an email, the same does not preclude it from being a valid extension of time. Respective tribunal, if I may refer the tribunal to clause 10 of the EPC contract, which deals with the extension of time, it states that the affected party can apply for an extension of time via giving notice, and that if the employer agrees, an amendment can be made. Over here, we would like to stress upon the use of the word can. We would like to state there is nothing to indicate contrarily that this is the only way in which an extension can be asked for or can be claimed. And further, it is our submission that this was not a mandatory obligation. Respected tribunal, it has been held in various cases that a term such as must might imply mandatoriness, but a similar conclusion can definitely not be drawn for the term can. Respected tribunal, it was held in Green Rubber Industries that the term can or any other such weaker term must be interpreted in light of the circumstances that surround the case. And in the present matter, as is evident from annexures B and C, the parties had been carrying out all communications through email. Further, there had been no issue raised by the employer with respect to this request being raised through email with respect to extension of time. On the contrary, the same was agreed to by them by the email sent on 3rd March. And if I may note that it doesn't seem valid for them to bring this up at this stage. Further, we can also see from the conduct of the claimant itself, a valid extension of time had been given, and there was no rising claims with respect to the mode of notice, which was so heavily stressed upon by my opposing counsel. Acceptance of extension is not prescribed a mode, and this acceptance through conduct was therefore possible. In the present situation, the email exchanges, the forbearance during the weekly meetings, the acceptance of performance, and also acknowledgement of the same without any rising claims, and also payment with respect to the design phase, all of the same indicate that the revision of timelines was amenable and the same did count as a valid extension of time. If I may, respected tribunal, I will move now to my second submission, which is that there was no breach with respect to the refurbishment stage either, the same pertaining to the force majeure clause. Members of the tribunal, at the very outset, it may be stated by us that the respondent has expressly indicated a willingness to complete the project per the revised timelines. For the same, I will refer the tribunal to paragraph 28, and under that point 5, it is stated by us that we would want to complete performance according to the revised timelines. However, we are still arguing our case with respect to how the temporary suspension of works in the light of pandemic does not amount to a breach either, as the force majeure clause was indeed validly invoked by the respondents. In this matter, respected tribunal, the claimant has held the view that because the list of exemplifications for availing the force majeure clause did not explicitly feature the word pandemic or lockdown, the same was not validly invoked. And secondly, as was stressed upon my co-counsel, the same was not validly invoked because there was no written notice that was given. And it is in this context that I seek to establish, firstly, that the condition of notice by itself cannot be considered mandatory. And secondly, that the list of circumstances for availing force majeure as given in 9.2 were also not exhaustive. If there are no questions at this stage, I will move to my first submission here, respected tribunal, which is that the written notice was not mandatory. All right, reiterating my own. Yes, indeed.
How do you take advantage of force majeure when the alleged breach happened much before that, right? I mean, you can't even take advantage of it. It's only, once the pandemic is declared, right, then only the force majeure clause can be invoked. But you invoked it only on 23rd March, but the alleged breach happened much before that. So how do you take advantage of that clause? If at all, assuming that the pandemic is covered under the force majeure.
For sure. Thank you for your question, Mr. Arbitrator. Firstly, if I may clarify once again that with respect to our force majeure clause being invoked, the same was only invoked for the third stage, which was the refurbishment stage. And during that time, it would be relevant to invoke force majeure in light of the pandemic, as the pandemic had already hit. However, with respect to your question, with respect to alleged breaches previously, that was what my first submission was pertaining to, which is that a valid extension of time had been given to us, so the same was also not breached. If that satisfies, Mr. Arbitrator?
If the intent was to seek extension of time.
I can't hear you, Mr. Arbitrator. I don't know if this is just me.
Are you able to hear me now?
Yes, yes.
Okay. If the intention was to seek extension of time in terms of the agreement, why was there no specific mention of the clause that in terms of such and such clause, we are seeking extension and satisfy those conditions, if that was the intent?
Indeed, I understand, Mr. Arbitrator, and it was our understanding that it was assumed by the parties that this is indeed an extension of time which we were seeking, because as has been the submission of my co-counsel as well, that the only situation, because their submission is that this contract is one where time is of the essence, the only situation in which any extension can be given would be by clause 10. Therefore, it can be implied that our extension was given under the same. However, members of the tribunal, I would still like to address this concern just in case, because it is indeed our submission that time was not of the essence. So the same can still amount to a revision pursuant to the contract itself, pursuant to the General Contract Act, which applies in Asgard, which is the Indian Contract Act. Section 62 and 63. These are my apologies. Section 62. This section gives liberty to the parties to flexibly alter the contractual terms and obligations whenever they consider necessary, and the same allows them to bypass strict contractual terms. If I may move to my previous submission.
Would you agree that unless we decide the extension in your favor, you can't get benefit of force majeure?
No, Mr. Arbitrator, that would not be my submission. We would still get benefit of force majeure. If you do indeed agree that there was no extension of time, we would then be held in breach with respect to the first two phases. However, with respect to the third phase, force majeure would still apply.
Proceed.
All right. So my first submission under force majeure is that the condition of notice, as was stressed upon by my co-counsel, was not mandatory. If I may just direct the respected tribunal to the phrasing used here, which is that the affected party shall give a notice in writing to the other party in the situation that they wish to invoke this clause. As has been argued earlier, a term such as shall does not indicate any mandatoriness by itself, and surrounding circumstances have to be looked at to impute a meaning to the term. And it is humbly pleaded, respected tribunal, that the circumstances surrounding the contract did not in any stretch of imagination suggest that the written notice was intended to be mandatory. And the reason I'm saying this is this can be derived by two submissions. Firstly, that the purpose of force majeure would not allow it to be mandatory. And secondly, that the principles, yeah, indeed, Madam Arbitrator.
If you read this in light of the no oral amendment clause, you're saying...
I'm so sorry. I think there's some problem on my end with network. If you could repeat your question, Madam Arbitrator.
Tell me now.
Yes.
How would you respond to this in light of the no oral amendment clause? You're saying that the requirement for a written notice is not mandatory. But
Indeed.
How would you that there is a specific clause which says no oral amendment to be made?
If you could direct me to this clause you're referring to, Madam Arbitrator.
Clause 226.2 of the EPC contract.
Right. So, Madam Arbitrator, if I'm understanding you correctly, what you're stating is that an amendment was necessary by virtue of 26.2. However, 26.2 by itself can only be considered and invoked when there was, firstly, a notice required in the first place. So, from what we are arguing, the entire clause 10 itself was not mandatory. And therefore, by extension, clause 26.2, which comes after clause 10, was not mandatory.
Okay.
Right. So, moving back to force majeure, this is my
If
submission.
I can understand, your basic case is 10 is not mandatory. It's basically completely up to you to do what you want to do when it comes to extension of time. And it's not that there was an effective notice. You're essentially saying that the notice provision didn't apply. So it really doesn't matter, how 26.2 is dealt with, because 10 is pretty much ineffective.
Right. It is indeed my submission, Mr. Arbitrator, that because the term used in clause 10 was that a contractor can apply to the employer by virtue of this clause. So, which is why I'm stating the same. However, my present submissions are not with respect to the same, if I may clarify.
I'm sorry, I didn't understand that.
Right. So I'm just stating that my present submission is with respect to clause 9, not clause 10.
Yeah, no, I got that. Thanks.
So with respect to clause 9, I'm stating that the same is not mandatory in light of the principles of business efficacy and the purpose of the force majeure itself. And for the same, I would like to refer the tribunal to clause 9.1's exemplifications, as they called them, which include situations such as calamity, war, political insurgency. All of these are situations which tend to cause disruptions to postal services. Further, we would like to give address to the tribunal that when we had sent the email, we got a response as an automated reply which said the subject is out of office. So what we understand is that their office was closed, much like many offices across the country because of the governmental lockdown. Thus, even if we wanted, we could not have followed the exact requirement pertaining to notice under 26.3 because the same wanted us to hand deliver it to their office. Further, we would like to humbly submit that the circumstances in clause 9.2 are not exhaustive in nature. In regard to this, it is humbly submitted that the contractual terms have to be read as a whole, and the same is a well-accepted principle. And with the same being said, I would like to refer the tribunal to clause 9.1, which corresponds to page 16 of the moot compromise. If I may read it for the convenience of the tribunal, it reads that a force majeure event can mean any event which directly or indirectly prevents performance or delays an affected party. Towards the end, the clause reads that the force majeure event may be natural or non-natural as per the below, following which there is a list of exemplifications. Members of the tribunal, it is strongly asserted from the side of the respondent that nothing in the clause suggests that these exemplifications are the only events under which a force majeure may be considered. The phrasing as per the below by itself does not to us preclude any additional events as there are no exclusionary terms such as only per the below and no other no other circumstances being considered. On the contrary, respected tribunal, one finds that the very first line uses the word any event, and it can be therefore seen from the clause itself that this does not preclude the pandemic from its ambit.
So was the notice under
sorry, go ahead.
Sorry.
Jane, go ahead.
Was your notice indicating force majeure within 7 days, which is required under 9.2?
Right. So, Mr. Arbitrator, if we are to consider our email as a notice, because as had been mentioned by me previously, we couldn't have hand delivered a notice to them, to their office, as their office was closed. The email itself was sent as soon as it was made available to us, the knowledge that there was a lockdown. The same was made available on the 22nd of March by the government of Asgard on 2019, and we sent our email on 23rd March. If I may continue, Mr. Abhishek?
I've got a question then.
Yes.
What's the purpose of the last sentence of 9.1 and the two lists of examples? If the entire question is answered by the use of the word any in the first sentence or the first part of the sentence, Why have we included this additional language?
Indeed, Mr. Arbitrator.
That was before you answer. My question was precisely on the same topic, which is the council aware of ejusdem generis, and would you have any comment on its application to the interpretation of this clause?
Right. And I thank you both for your questions, Mr. Arbitrators. Firstly, with respect to the fact that there's the last line, which says that it says as per the below, it is our submission that the same does not have any language which is exclusionary. It does not by itself state that that there are other circumstances which cannot be considered. And as was noted by the claimants themselves, these are simply examples or exemplifications. This is the very term used by them in their own email, and thus by their own admission. Further, with respect to ejusdem generis, what I understand is that when there's a when there is a general clause, the same will be qualified by a specific clause. And over here, the same is not, firstly, it is our submission that the same is not a specific clause. However, it has been stated that even if the ejusdem generis principle is to apply, specific clauses can still include other circumstances as long as they do not deviate very far off from the various exemplifications given. It is our submission that the pandemic does not deviate from the other circumstances.
Do you have any legal authority on the use of ejusdem generis in force majeure clauses?
Currently, I do not, Mr. Arbitrator. I apologize. However, I would state that in recent judgments, it has been held that there must be harmonious construction of the entire force majeure clause. And over here, because the first introductory line itself uses the term any event, we would state that a harmonious construction would indicate that the same, even by ejusdem generis, requires that it be not exhaustive. If I may move to my issue on, I see that I have only 2 minutes remaining. If I may move to my issue with respect to remedies, Honorable Tribunal.
Yes.
Right. So under this, I would like to seek, I would like to establish firstly that the remedy of specific performance cannot be availed by the by the claimant, and the remedy of liquidated damages also cannot be availed by the claimant. But firstly, I would like to state that the respondent's actions do not constitute a breach of contract in the first place. And all remedies can only be given in such a circumstance where it is held that there's a breach of contract. Thus, this is all arguing in the condition that this tribunal holds that our first submission does not hold true. With respect to specific performance, Honorable Tribunal, we state that their specific performance relief will be barred by sections 14 and 16. I will plead my strongest defense in the form of subsection C of section 16. If I may be granted a 1 minute extension, and I will be able to complete all my submissions.
You may have 3 minutes.
All right. Thank you so much, Mr. Arbitrator. That's very generous. I will then plead even section 14. Firstly, starting with subsection C of section 16, the same bars a remedy of specific performance in favor of a claimant who has failed to prove their readiness and willingness to perform the essential terms of a contract. In the Mehboob ur Rahman case, it was held that part of proving this readiness and willingness is blemishless conduct on the part of the claimant, which is basically fulfillment of all of their obligations needed for performance, as well as timely acceptance of performance. It has been held strongly across cases that in any situation where it may be inferred that the claimant's actions itself have played a part in delay, the same would also affect their case negatively. In the present situation, the claimant has failed to establish such blemishless conduct throughout all three phases. I will pose my strongest 3 points with respect to this, each corresponding to one of the phases. With respect to the procurement phase, we see that they have failed to pay 40% of the contract price, which is their major obligation with respect to payment under clause 3 of the EPC contract. With respect to delaying performance of their obligation to ensure availability of their team during the design phase and availability of all necessary documents for the design phase with respect to the first phase, that is. And thirdly, their failure to obtain permits for commencing the refurbishment stage in time. Even generally speaking, Honorable Tribunal, a lack of responsiveness was observed from the side of from the claimant in their email communications. There were often minor delays, and it can be observed that at each phase, therefore, the claimant was not by itself blemishless in any form. Often, the cause of non-performance was therefore also in the first place the claimant's conduct itself, which is why they cannot be entitled to specific performance as per Section 16. With respect to Section 14, subsection 1, it's 1D, if I may clarify, it states that the specific performance cannot be granted in situations where there's a contract of performance which involves a continuous supervision or duty upon the court for continuous supervision in order for there to be enforcement of the contract. Over here, it is submitted that this is a building contract of a highly detailed technical nature, and also has been seen, these are uncertain times. A lot of revision of timelines has taken place already, and we anticipate that more may occur. It is our submission, therefore, that there will be frequent decision making, and this would disrupt the functioning of the tribunal itself, as the tribunal will be responsible for the execution and for the supervision of the same. With respect to our submissions about why the claimant is not entitled to liquidated damages, we would like to submit firstly the claimant has not suffered any actual loss. Under Section 74 of the Indian Contract Act, it is necessary to show that there was an existence of actual loss. We understand that the quantum of the same is not necessary as by the section itself. However, the existence of the same is mandatory to be evidenced by the claimant, as has not been done by them. And secondly, we would also like to submit, as has been told by us earlier, that the delays in execution are not attributable at any stage to the respondent. The same is
on liquidated damages. Would you not agree that it's a genuine pre-estimate of loss that both parties have agreed upon?
Mr. Arbitrator, the general pre-estimate of loss, what I mean to say by that is that it must be shown that there was actual loss for liquidated damages to occur in the first place.
Actual loss comes next, but would you concede that the liquidated damages represents, in this case, a genuine pre-estimate of loss by both parties?
I don't think I would concede that, Mr. Arbitrator. The reason I'm saying that is because the quantum is quantum by itself may not be important, and the genuine pre-estimate might pertain to the same. However, the existence of actual loss amounting to damage or amounting to a loss of profits, the same, in the absence of the same, there will be prejudice to our party, because without the same, there will be an obligation for us to pay, even though there was no actual loss.
Noted. Unless there are further questions to my colleague arbitrators, maybe Mr. Jain has one.
Yeah. So did you not agree for specifically performing the contract by first seeking extension, secondly, by invoking force majeure, and not seeking termination of the contract? Because you said keep the agreement in suspension, right? Therefore, your intent was to specifically perform it.
Indeed. And Mr. Arbitrator, before anything else, if I can ask for an extension of 1 minute to answer your question.
Yes, please.
It is our submission that we do actually, this was one of the points that I had raised earlier, that we have actually been conducting specific performance of the contract. We fail to understand why it is that the claimant has brought up this remedy, because as has been told by us earlier, we have indicated to follow the given timelines. However, we are still preemptively arguing the same, just in case that they disallow us from again suspending performance in case of there being genuine concerns, as was in the case of force majeure. If the same satisfies Mr. Arbitrator. All right.
I think we take it that you've concluded your submissions. Thank you, Counsel.
All right. Thank you, Mr. Arbitrator. Thank you, members of the tribunal.
Thank you. Would the MCS team have any comment now, or shall we formally conclude this hearing?
Mr. Arbitrator, I believe the rebuttals are remaining.
Okay. Is there an agreed designation of time? Is there one counsel each on the other side, on each side to speak?
Yes.
Mr. Arbitrator, sorry.
Mr. Arbitrator,
we would be following the RCCR. Okay, sorry.
All right, once more. And how much time, please, do we have for each of the rebuttals?
Both the teams have 4 minutes left, out of which they will allot 2 minutes for rebuttals and 2 minutes for rebuttals.
Okay, thanks for the clarification. So on that basis, the first R of the RCCR, please.
Thank you, members of the tribunal. I shall now proceed. Now, before I begin with my rebuttals on the procedural issues to the arguments of learned counsel for the claimant, I shall answer the question raised by Mr. Jain with respect to the law applicable to the arbitration agreement in the present case. Now, to answer Mr. Jain's question, I would like to state that if reference is made kindly to clause 26.1 of the EPC contract given at page 17, it clearly states that we would note that the non-contractual disputes, that is the arbitration disputes, shall be governed and construed in accordance with the laws of Asgard, that is the laws of India in the present case. Therefore, to the arbitration agreement, the laws of Asgard will be applicable. Now, if I may begin with the rebuttals to the arguments made by the counsel for the claimant. Now, I shall be giving two rebuttals. Firstly, the counsel for the claimant has mentioned that the arbitration needs to be conducted expeditiously. However, it is a submission that an effort to conduct arbitration expeditiously cannot be at the cost of ensuring a fair hearing to the parties. Now, in the present case, remote hearing is marred by due process concerns of witness examination, confidentiality, and among other things. Now, we submit here that no prejudice to the claimant will be caused if a bit of delay is caused in conducting a physical hearing, as the construction works in the present contract are currently ongoing and have not been stopped. So, even if the hearing is delayed by some amount of time, and to conduct a physical hearing, no prejudice will be caused to the claimant. Secondly, the learned counsel for the claimant has made reference to the Delhi High Court case of Ravindra Kumar Verma versus BPTP to say that the pre-arbitral clauses are unenforceable and non-mandatory. However, the facts of this case are completely different as the case cited by the claimant. In the case that the claimant has cited, the only requirement in the contract was that the parties shall resolve their dispute through mutual discussions. However, in the present dispute, there is a three-step multi-step dispute resolution mechanism provided to the parties. And in that case, the parties did not have any other alternative than mutual discussions. And if the mutual discussions requirement fail, the parties would not be able to resort to any other alternative. But this case is different from the case that the claimant has cited, and therefore the case cannot be considered valid in the present case. Thank you, members of the tribunal.
You. Unless my colleagues have any questions, should we proceed to hearing the next counsel, please? All right, counsel for the claimant, please.
Members of the tribunal, my learned friends from the side of the respondents have raised three objections. Firstly, with respect to the due process concerns primarily of witness testimony and confidentiality. As I have earlier submitted before this tribunal, that Schedule K of the SIAC guidelines to remote hearing give detailed procedure as to how witness testimony shall be conducted in a remote hearing, giving sanctity to witness testimony. And with the issues of confidentiality, FAQ 3 of the SIAC remote arbitrations guidelines, and question 16 with respect to the platform that is provided of the issues concerning, and the platform being the platform provided by Maxwell Chambers in this regard. Secondly, with respect to the delay, to a small delay and then again convening physical proceedings and doing away with a virtual one, members of the tribunal will kindly appreciate that this particular proceeding has been delayed by almost 1 year now. The whole need for an arbitration proceeding is that the disputes will be redressed in a speedy and efficacious manner. If it is further delayed, time being the essence of the contract, there is no need to arbitrate then in the first place, and the whole spirit of arbitration is done away with. Thirdly, my learned friend said that I had quoted a case of Rakesh Kumar Verma. I had never quoted such case. Members of the tribunal, what I had quoted from the Delhi High Court was Sarvesh Securities versus MD DCCIC, which reproduced a clause similar to the one at hand, which has been reproduced in paragraph 14 of the said judgment. The mediation clause was not adequately described with respect to a time frame and the process of selection of a mediator. Also, the fact that in India, there is no act with respect to mediation as to how, when it is vaguely described, the same shall take place. In that regard, I rest my case.
Thank you. Unless there are further questions, my colleagues will hear from Claimant Counsel number 2, please.
Indeed. In the rebuttals for all the issues on merits, first being that it has been laid down in ONGC versus Western Gecko International, paragraph number 18, that at the time of acceptance of performance, the waiver of liquidated damages has to be explicit and expressive. And therefore, it could not be said that because we've made payment in design phase, we've let go of the liquidated damages. Secondly, pointed out by the Council on the behalf of the respondents, that Section 63 of the Indian Contract Act gives the opportunity to the parties to remit performance and revise timelines. However, Section 63 of Indian Contract Act only enables the promisee to remit the performance of the contract and not both the parties. Regarding the continuous supervision of the courts, in this regard, in the judgment of Her Highness Maharani versus Sabji Bhai, a Supreme Court judgment in 2001, the conditions were laid down when continuous supervision would not be burdensome, which includes a project of national importance, which is the present one, and also that the substantial portion of the contract has been completed. And in this regard, the design phase and procurement phase have already been completed. Lastly, the contention of the respondents that we will have to prove actual loss in order to claim damages. In the Supreme Court case of Gale Limited versus Geo Miller and Company 2011 judgment, when the project is related to a public utility project, which was construction of roads and bridges in the present case, no actual loss needs to be proved. And also in Mola Bucks versus Union of India, it has been held that liquidated damages are pre-estimated damages. And in that case, no actual damages or loss needs to be proved by the claimant. That is all.
Thank you very much. On the same terms as the earlier, can we please hear from the final counsel, respondent number 2, counsel number 2 for the respondent.
Indeed. Firstly, I would like to thank my opposing counsel for laying out her concerns so clearly. With respect to the case you mentioned about how ONGC was, I believe a case with ONGC was saw pipes was mentioned, and how waiver of performance must be explicit. I would like to direct the bench and also to my opposing counsel that there was a meeting that was conducted on 16th August 2019, where there was an explicit agreement that took place. The same was not by conduct, but by the actual meeting of the parties face to face. There's also a record of the same in the minutes of the meeting. With respect to the question on actual loss, we understand what you're talking about with respect to how there may not be requirement of quantification, especially as this was a case of social welfare and public importance. However, the existence of actual loss, as was claimed by me in my pleadings as well, is definitely necessary to prove nevertheless, as the absence of the same would cause prejudice to us in this case. And with respect to the Delhi High Court case that the other counsel brought up and how it was not there in their pleadings, we would like to direct them to their own submissions. It was there in your written submissions that this case was used. I thank you for your time, Honorable Tribunal.
Sorry, I have a question for you on this. Are you aware about the decision of Supreme Court in Kailash Nath's case? And if yes, then what is the law laid down in terms of damages?
Just give me one moment to answer your question, Mr. Arbitrator. Over in Kailash Nath case, it was stated that from what we understand, the precise quantum or calculation may not be necessary, but the requirement of actual loss being there is still necessary.
And would I mean, according to you, will this case apply, and the legal proposition in terms of what the speaker 2 for claimant said, that in case of where there is government involved and public projects and everything, that quantification is not required and the actual loss is not required?
So, Mr. Arbitrator, my submission, and I believe that's what my opposing counsel was saying, that it's not quantification of loss she was talking about. She was talking about, it's not actual loss she was talking about. She was talking about quantification of actual loss, as she also buttressed her argument with respect to the pre-estimates. Therefore, we do still believe that the existence itself has not been proven to us. We do not believe that the same was a high burden. It's just not been proven to us by the claimants.
Thank you.
I thank my learned colleague arbitrators for their patient hearing. Thank the counsel for their clear exposition of the case and hand it over back to the new court society. May I note, given the late hour, perhaps the tribunal may not need the full 15 minutes that was proposed by the MCS, and perhaps we could do with a shorter deliberation time.
No, sir, surely. So I'll just create a breakout room now, and we can just finish the deliberation as long as it takes. That's all right. I'll just create a breakout room where I just send.
Perhaps it would be prudent to stop the live recording in case of an inadvertent
So
broadcast.
actually, I was assured that a breakout room will not go on the broadcast. So I think it should be fine. We'll just keep a watch on it.
Thank you.
I'm about to suggest that.
Manav, if it's okay, I have a breakout room ready. Can I assign the judges?
Okay, yeah, go ahead.
Judges, you should be able to see the link. You can join the breakout rooms. Let me know if there's any issue.
Exam prepare பண்ணப்பா.
The teams can switch off your videos and unmute yourselves. I'll let you know when the judges are back in.
Yes, just give me a second. Hi, yes. So we've come to the conclusion of the final. I hope all the judges and the participants had a great experience. So first, I would ask Mr. Shreyas, the panel chair, to announce the winning team's score.
What has proved to be a close contest, the tribunal has unanimously held that Team Calibri has prevailed. Many congratulations.
So congratulations to Team Calibri. And I'd just like you all to stick around. So first, I would like Mr. Nitesh Jain to announce who is the winning team, the college, the actual college.
Yeah, so it's Symbiosis Law School, Noida.
So thank you, sir. Congrats to the winning team. And then I would like Mr. Vivek Kapoor to announce the team which has come as runner-up.
Right, and it is NLUD. I don't know what that means, but
Sorry.
congratulations to them. That's National Law University, Delhi, I think.
Yeah, it's the National Law University,
Congratulations.
Delhi. And I would like Mr. Finizio to announce who is the best speaker on the side of the in the whole mood, just based on the prelims.
I would love to do so, but have you sent me the? Have you sent
Yes,
me?
yes, yes.
Where am I finding that?
So I've just DM'd it to you on Zoom.
On Zoom, hold on. I'm not. I apologize. I'm not seeing it.
So you can just see the chat.
Ah, thank you. It's Mansi Satya Jain from the School of Excellence of Law. Congratulations.
Yes, and I would ask Mr. Jaisama to announce who is the best memorial claimant.
The Claimant Best Memorial Prize goes to National Law University, Delhi. Many congratulations.
And finally, Ms. Biduri, I would like you to announce who is the best memorial on the side of the respondent.
Institute of Law, Nirma University.
Yes, thank you, everyone. That concludes our prizes for the NLSTIM. So we've come to the conclusion of the 15th edition, and I hope it has been a great experience for the participants and for the judges today. So I would first like to invite Mr. Nitesh Jain, who is a partner at Trilegal and is Trilegal being our title sponsor. I would like you to say a few words, sir, on behalf of Trilegal and in general about the moot.
It's been a great pleasure. Thank you for all the arbitrators, friends, right, and all the participants. I mean, of course, it was a, interesting, topic, right, where interesting procedural issues as well as substantive. Covering what's happening in terms of the legal issues across, right? I mean, it's not limited only to the Indian cases, but also abroad. So well done in terms of, the topic and what the participants have done, and well done to Manav and team in terms of coordinating and organizing it. So it's been a, real pleasure for Trilegal to be continuing, associated with this. Thank you.
Thank you so much, sir. And next, I would like to ask Ms. Shweta Biduri to speak a few words on behalf of SIAC, who has been our long-time collaborator.
Thank you so much, Trilegal and the National Law School for having us. And I think it's been a pleasure, to collaborate on and have the moot competition problem based on the SIAC rules. And if I could just generally say, of course, it was a very interesting competition. I think generally international arbitration has come such a long way, and it is so good to see, students warming up to the issues and to really be on top of a lot of these things. And I'm sure I'm going to see you all on the other side of the bar, as lawyers, as practicing arbitration practitioners soon. Yeah, so thank you so much. And I think, while there's been an announcement of a winner, I think all of them are really, this is really the platform to train and really polish their skills, which will only get better with time. I think so. This is a great training and platform and experience for all of you and for all of us, to see how we're seeing such new talent come up. So thank you for the opportunity and all the very, very best, for your future endeavors. And we see you as excellent arbitration practitioners, and some of them at the SIC arbitration soon. So thanks a lot.
Thank you so much, ma'am. And I would also ask Mr. Shreyas Jaisama to say a few words as one of our eminent alumni and who also contributed on the drafting committee. I would like him to say a few.
Thanks for the overly generous introduction. But it's been a pleasure to interact with everyone on this session of the moot. I was involved with some of the early stages, and so in absentia, I'd like to thank all my other colleagues who helped with the framing of the moot problem. And I understand that the organizing committee had to juggle many last-minute changes and perhaps even some logistical difficulties. So many congratulations to them. And finally, the participants, your enthusiasm matters. I hope that you'll retain the interest and enthusiasm beyond this moot. And as Shweta said, keep your sights high and now see yourself as part of a global community of practitioners and aspire to reach further and higher in setting your own personal standards of excellence without waiting to be nudged by any external force. So wish you all the very best. God bless.
Yes, and also last but not the least, I would like to ask Mr. Vinay, who is from our online platform called, to speak a few words. And I would say, we could say that this 3 years of online has kind of been it's not a really good thing, but we're also lucky to have interacted with people like Mr. Vinay. For the past 3 years, we've been collaborating with CORD, and it has allowed us to conduct the rounds seamlessly for the past 3 years. So Mr. Vinay, if you could just say a few words.
Thank you so much for that introduction, Manav. It has been a pleasure working with you guys as well and a privilege as well. And congratulations on yet another successful edition of NLSTIAM. Thank you so much for your faith in us and choosing us as a tech partner for the event 3 years in a row now, right? Just a quick word about us for those who are not familiar. We are a company seeking to infuse technology into dispute resolution. We operate under 2 umbrellas now, CORD and Terrace. CORD is a dispute resolution institution which the technology, again, at the technology platform at its heart. And we use technology at every step to make arbitration more cost efficient and time efficient. As of today, we are completing around our arbitrations in under 60 days and at less than 5,000 rupees. And we are hoping to bring that down to under 60 seconds where possible. So the idea is, arbitration largely is today seen as a mechanism that is available only to high value disputes. And CORD actually is breaking that image and bringing it to the masses. And in order to deliver this at scale, we use advanced case management solutions and a combination of AI to make that possible. And in that regard, we are also actively encouraging younger practitioners like you to start resolving disputes and then start off as arbitrators, while also internally as a platform ensuring that we have adequate checks in place so that we are bringing in quality arbitrators. And then our second flagship, Terrace, on the other hand, focuses on complex, high-value disputes, and we provide international quality services such as transcription and document management, again, infusing AI. And it's, in fact, a couple of members of the panel here, Shreyas and Shweta, have already used our platform and our services, and they will let you know of the experience with that. It's a matter of pride for us that internationally renowned eminent practitioners, firms like Trilegal, White & Case, etc., have not only used our platform, but have gone on to record, gone on publicly to appreciate and recommend our offerings. To date, we've conducted over 1,000 hours of arbitration with participants from Hong Kong, Singapore, London, Qatar, Mauritius, etc., and including arbitrations from ICC, SIC, LCIA, MCIA, and so on. Just to conclude, we've seen that law has traditionally been lagging behind finance and medicine when it comes to tech adoption, and our current solutions not only meet the solutions available in advanced jurisdictions. In most cases, they surpass the available technology there. And the younger practitioners to whom technology itself now is second skin, right, are ideally placed to ride this wave. So maybe next year we'll beam you guys up into the metaverse and conduct the next edition of NLSTIAM there. Thank you so much. All the best, you guys.
Thank you, sir. So I'd just like to wrap the ceremony up by thanking everyone who has helped us with the mood. Firstly, our title sponsor, Trilegal, and SIAC, and Walters Kluwer, who is helping us sponsor a few of the awards, and also CORD. And I would like to thank the drafting committee, which comprises, of course, Mr. Jessima, and also Professor Albert Jan Vandenberg, and Pratyush Panjwani, and also Mr. Akshay Puri from Trilegal. And obviously, last but not the least, I would love to thank the organizing committee. V. Ashish, my joint convener, is here, and the rest of the organizing committee, with Chanakya as one of the members. And I would also like the participants for coordinating with us over these past 4 days. It has been hectic for us. It has been hectic for you, but together we've managed to conduct an event of this scale even online. So thank you. I think that about wraps up the presentation.
Congratulations to everyone.
Exactly. I was about to note again, Vivek and Stephen in particular, joining us from a different jurisdiction. And perhaps you would like to ask them to speak for a second or two, please, since they've spent so much of their time.
Yes, surely, sir. Mr. Vivek has actually agreed to join us on such a short notice, and I'd like to thank you so much for that. If you would like to say a few words.
Thanks a lot. It was a pleasure to be part of this wonderful mood, and my congratulations to the participants, and all the very best.
So, and of course, Mr. Finizio, actually, Wilmer Hale has been a long-time collaborator of ours. We've had judges coming down. We've had them participate in our conference as well. And he has been a consistent judge in the TIM. So, of course, sir.
Well, thank you. No, I will just echo what Vivek just said. It was a pleasure. I'm very glad to have been able to participate. And I just want to congratulate not just the students who are at the heart of this, but all the people who made this work. And my observation would be, I thought the problem this year was particularly apt, reflected important real world events. And I think as Shreya said earlier, hopefully this is also, for those of you who are coming to this as students, an introduction to an exciting opportunity to pursue international arbitration. So good luck to everyone, and thank you for allowing me to be involved.
Yes, thanks everyone. I think that about concludes the presentation. Goodbye and good night.
Thank you.
Thank you. Thank you.